All rise. First District Court of Appeals now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, great state of Florida, and this honorable court.
Thank you. You may be seated. Good morning. We have one case on the docket this morning for argument. Case number 24-1065, Miami-Dade County and others versus Florida Department of Economic Opportunity and others. 20 minutes per side. I hear that you're splitting arguments. I'll leave that to you to figure that part of it out. Counsel for appellant.
Good morning, Your Honors, and may it please the Court, Christopher Wall here with my co-counsel Eddie Kirtley on behalf of Appellant Miami-Dade County. This morning I will argue the first of the two issues presented in this appeal, that the Department lacked the delegated authority to determine whether the aligned amendment had been adopted in accordance with statutory deadlines after the Department's 5-day review period had expired. What the Department asked this court to countenance today is an extra statutory loophole that has no basis in law. That loophole would bestow upon the Department the perpetual power to declare that local government adopted plan amendments were improperly adopted weeks, months, or even years after the amendment has been adopted.
Very quickly, Mr. Wall, you want to save 2 minutes for rebuttal? Is that?
Oh, I'm sorry. Yes, please. 2 minutes. In the meantime, local governments could further adopt their comprehensive plans contingent on the effectiveness of this plan amendment. Similarly, private property owners could expend significant resources developing their property in reliance upon the effectiveness of this plan amendment. All this only to have the Department step in much later and, like a game of Jenga, pull out the bottom piece and cause the edifice to collapse.
So in the statute, it's called Expedited State Review Process for Adoption of Comprehensive Plan Amendments.
Exactly.
So walk us through the timeline and tell us how this was expedited.
So the expedited review process refers to the state's review process.
Okay.
And the deadlines in the statute, of course, constrain both the department and the local government, depending on what the deadline is. But ultimately, it's an expedited review process for the state, not the local government. So the way it begins.
But it seems to put a 180-day deadline on local government to finish their work on this, and it provides for an extension, which was done, and it still wasn't done within the time allotted.
The second public hearing was held within the time allotted, and that's the issue my colleague.
So your argument is just having the hearing is good enough?
Yeah, the second public hearing, Your Honor, yes.
Okay.
And my colleague, Mr. Jazeel, is going to go into detail. Of course, I can discuss that as well. And that is one of the ironies of the department's delegated, or rather lack of delegated authority argument. It's that there's deadlines in the statute that bind the county. There's deadlines in the statute that bind the department. And yet when it comes to this ability, this extra statutory ability to declare that plan amendments were improperly adopted, there's no deadline governing when they have when they can do so. That's their argument.
So pre-2011, the statute said the local government should have 60 days to adopt the amendment. Okay, that seems pretty clear.
Mm-hmm.
And then it was amended, we have the language, the 2002 language that we're operating under for this case.
Right.
And then we have some 2024 language that says, hold a second public hearing to adopt the comprehensive plan amendments. But the language we're trying to figure out what it means is shall hold a second public hearing, which will be a hearing on whether to adopt one or more comprehensive plan amendments pursuant to subsection 11. And
Yes.
we're trying to figure out what that means.
Exactly.
Okay.
Exactly. And that's the core issue in this appeal. The threshold issue is whether the department had the authority even to make that determination in the first place. Our argument is that, yes.
So the determination is they sent you a letter and said this is late and it's deemed withdrawn.
Correct.
Correct.
Correct, yes. That's the determination. And the department had the authority to make that determination during the 5-day review period under subsection 3C3. That was the time the department had to identify any deficiencies in the amendment. And here, the department didn't identify this purported deficiency until weeks after that 5-day review period expired. That's why count one of our
So
complaint.
we had months and months and months of process where it was not adopted. And then the department, because they waited more than 5 days, they're done, is your argument.
Yes, Your Honor. And the reason why is because the statute imposes specific deadlines for certain actions against the backdrop of this is legislative action by a local government. Local governments can consider legislation under their consideration for as long as they want. Here, there were certain requirements imposed by statute, but the county complied with those. It held the second public hearing before the extended deadline expired. Once it held that second
So
public
you
hearing.
say under the 2002 language, there's no deadline for the county to complete this process?
Correct, Your Honor.
Okay.
And that's the case with any legislation the county adopts, and comprehensive plan amendments are legislative acts. So,
Was your position or understanding of the statute closer to what the departments, or was it the same as the departments back when you wrote the, when you requested the extension? January 26, it starts off and says, the review was completed under the state expedited review process. There's a couple places in this letter where it seems that you're acknowledging that it needs to be adopted within 180 days.
in,
Toward the end, it says that, I got the wrong letter, sorry about that. Yeah, it starts off, this letter serves as notice of the 6-month time extension for the adoption of the application. And then at the end, it says, the applicants in Miami-Dade agree, they need the 180 days to conclude review of the pending application and for the board to subsequently take final action on the application. So it seems like your understanding then is very similar or the same as what the department is arguing now, and that now you're taking a different tack than what you said in your letter.
certainly the letter says that. That was a letter penned by county staff. That's what they wrote at the time. What county staff wrote at the time doesn't change the letter of the law, and nothing in the statute binds the county to how county staff phrase certain things. Plainly, the Board of County Commissioners' action was to continue to consider the amendment after the deadline to hold the second public hearing passed. So the county commission's action is what speaks for the county in this case, rather than county staff's letter there. So the county's position, as it was at the time of the county commission adopted the amendment, is the same today and as it has been in this litigation, that deadline was not to adopt. It was to hold the second public hearing, as the plain language of subsection 3C1 provides.
So the current statute gives 180 days after receipt to hold the second public hearing and to adopt the comprehensive plan amendment. So the current statute's clear that not only do you have to have a hearing, you have to adopt or not adopt,
Mhm.
right?
Yes.
Okay. Well, earlier you were telling me that the commissioners have legislative authority to adopt things whenever they want to. Well, the current statute puts a timeline on them, and you're saying that the previous statute doesn't.
Correct, Your Honor.
Okay. But you're not arguing that the legislature putting a timeline on the commission acting is somehow unconstitutional or exceeds the authority of the legislature or hampers home rule or something like that?
Oh, not at all.
Okay.
No, not at all. We're completely simpatico with,
Okay.
And so I just wanted to address a couple other points on the delegated authority before I pass my time to Mr. Jazeel to delve into more depth on the issue of the deadline. Appellees argue that they didn't necessarily need to have delegated authority to make that determination that the amendment was not adopted in time because subsection 3C1 is self-executing. Well, first of all, there's no authority identified by the lower court or the appellees in this case that this provision is self-executing. But more importantly, the idea that it is self-executing contravenes the statute's express language. The statute expressly grants to the department this 5-day review period to determine whether there are any deficiencies in the amendment and to identify those deficiencies for the county.
Why wouldn't we read the any deficiencies language in view of everything that comes next in that part of the statute,
Because
as far as completeness goes.
yeah, that next sentence purports to define what completeness means, but it doesn't purport to define what any deficiencies means. So we have to give any deficiencies its plain language meaning. If the legislature didn't mean any deficiencies, it would have said deficiencies relating to completeness, and it said something.
So what
to
you're
that
saying is
point.
basically they have 5 days to raise anything, substantive, procedural, completeness, what have you. They've got 5 days. They don't have 30 days. They don't have more than 5 days to raise any objection to the plan.
I don't think it's, for procedural, yes. I don't think it's as broad as substantive, and the reason
You
why.
just said any deficiencies.
Yes, but you also have to read the statute in pari materia with the authority the department has under the statute to file an in-compliance challenge. The in-compliance challenge is based on certain substantive issues, and the statute enumerates what those issues can be. So it's not our position today that during that 5-day review period, the department has to identify everything that it's going to argue in an in-compliance challenge. I think
So we should read this statute when it says stuff like any deficiencies in the context of everything else the statute says.
Of course.
And when we see all earlier and when we see second public hearing and all the other issues are basically those are, all the issues in here are very similar. How do we view this whole statute?
Right.
Right. We're not picking out just 2 words, 3 words, what have you. It's reading it.
Of course, and I see my time is up. I was going to share it with my colleague, Mr. Jazeel, so I'd be happy to answer any other questions you have about delegated authority. If not, I would yield my time. Thank you, Your Honors.
May it please the court, Mohammed Jazeel for the property owners. Judge Roberts, I'd like to put the timelines into some context here. The timelines, if we look at 163-31-61 subsection 9, it tells us that the timelines are limited intrusion into the otherwise broad statutory and constitutional powers, broad statutory and constitutional powers being the language in the statute, of municipal and county officials as they plan for and regulate the use of land within their boundaries. So when we're looking at the timelines, we have to understand that the timelines are a limited intrusion into the local government's otherwise broad powers to regulate land use. Then when we focus in on subsection 3C1, which is the crux of the case, the question becomes, okay, does subsection 3C1 require the local government to hold a public hearing within 180 days with the extensions, or does it require the local government to hold a second public hearing and adopt the comprehensive plan amendment within those 180 days? Now, Judge Roberts, you mentioned the prior version of the statute from all the way up to 2011, and then the subsequent version of the statute that the legislature adopted in 2024. It's appropriate for the court to consider that statutory history, which is distinct from legislative history, and that statutory history tells us that the legislature knew how to say adopt. It's said it before, it's said it again, but in the version of the statute that we're operating under, it did
Or an
not.
alternate reading, it let us know that the legislature knew that there was confusion out there and they needed to be more clear.
That's one way to read it, Your Honor. Another way to simply read it is in 2010, there was a version of the statute that said in 60 days you have to adopt
Yeah.
something within.
Well, it seems to me that the operative thing, the thing you're looking for here is adoption. I mean, holding a hearing, that does not mean anything. That's an empty act. You know, they could hold a hearing and they could, you know, they could talk about Martha Washington or whatever, you know. That's not what we're looking for. We're looking for adoption so we can amend the comprehensive plan.
I disagree, Your Honor. If for your interpretation to be correct, you would need to collapse the meaning of adopt and hold into one. And when we look at the statutory scheme as a whole, that's simply not what the legislature was doing. They were using adopt and hold to mean 2 different things. Adopt was used to discuss when a local government can take an action on and actually approve a plan amendment. Hold was referring to public hearings. And so, Your Honor, I would suggest to the court that for us to say that the local government had to both hold and adopt a hearing within 180 days when both words do not appear in the operative statute, you would need to read a separate meaning into it. Now, my friends from the other side
Well,
So-
adopt is in this operative statute, right? Shall hold a public hearing, which shall be a hearing on whether to adopt one or more plan amendments. C1.
Yes, Your Honor.
Shall hold a public hearing, which shall be a hearing on whether to adopt plan amendments.
And then, Your Honor, it goes on to say, if a local government fails within 180 days after receipt of the agency comments to hold the second public hearing, the amendments are deemed withdrawn. And so the penalty that the department is imposing here, if we look at that operative sentence, is triggered when we fail to hold a hearing, not when we fail to hold and adopt. And so I think that's important, Your Honor. The penalty is triggered when the local government fails to hold. The penalty is not triggered when the local government fails to adopt. And, Your Honor, the trial court.
So as long as you hold the hearing with 180 days, you've met the statute, and adoption can be any time out in the future, or is there some limit to it?
It can be, there
I mean,
are-
because it seems to me that the legislature created a system where this is, where you need to do this fairly rapidly, not super rapidly, because it's government, you got to vote, and you got to have hearings. I understand that, but, things change. So if the agency signs off on it and sends it back to the county, and then 4 years later, the county says, okay, we've adopted it now. Circumstances on the ground, economic conditions, environmental conditions, all that can change. And that's why there's timelines, seems to me.
Yes, Your Honor. There are time limits. Also, we have to recognize, as I mentioned at the beginning of my comments, that this whole scheme is operating within the paradigm of local governments traditionally having control over land use. Local governments can have their own ordinances setting timelines for when certain things need to happen. If local governments fail to act, folks like my clients, the property owners, can file writs of mandamus, file actions in circuit court to otherwise trigger a response and to compel the local government to do its duty and to send something or adopt something after a public hearing. So those are the appropriate checks there. If we take a look at what the legislature specifically did when it intruded into the local government's otherwise broad authority to govern land use, the legislature said you're going to hold the second public hearing. It didn't say adopt. The court down
But
below.
then it says, all, in 3, or in 2, all comprehensive plan amendments adopted must be transmitted within 10 working days after the second public hearing. So it seems like here, that was 6 or 7 months. It wasn't within 10 days.
Yes, Your Honor. And the way we read it, it's all comprehensive plan amendments that are adopted shall be transmitted within 10 public days of the second hearing. What happens if the second hearing is not the one where something is adopted?
Well, then the 3rd and 4th and 5th might need to take place pretty quickly. I mean, this is a legislative-oriented body. The legislature has, first, second, third readings of things within 10 days, I guess. I mean, that can happen. If you're going to read the second hearing that way, then it seems like under 2, you got 10 days.
Or, Your Honor, another way to read it is if you're doing a third, fourth, fifth hearing, the 10-day requirement doesn't apply. And it makes rational sense for the legislature to say if a local government is modifying its local constitution, which is what a comprehensive plan amendment is, we're going to have quick review by the state. Because a hasty amendment to the local constitution is perhaps something worthy of quick review by the state. And there, Your Honor, again, I'd like to.
But counsel, wouldn't your interpretation of the statute render the 10-day deadline meaningless?
No, Your Honor, it wouldn't. The 10-day deadline would still apply to comprehensive plan amendments adopted after the second public hearing, which is what the statute says.
Which
What
10-day period did you comply with in this case?
Your Honor, we did not need to comply with a 10-day period as our position because a 10-day period was triggered if someone adopts a comprehensive plan amendment after the second public hearing.
Even though it says all comprehensive plan amendments?
All comprehensive plan amendments adopted by the governing body within 10 working days after the second public hearing to the state land planning agency. So I think, Your Honor, if a our reading is this: if a local government does not adopt the plan amendment at the second hearing, that's appropriate because subsection 11 talks about having multiple hearings. 2 is the minimum. So a local government can have multiple hearings and it can adopt something at the third, fourth, fifth hearing. And if we adopt something at the third, fourth, fifth hearing, it's something that wasn't hastily considered. It was something that was given a great deal of thought by the local government. And so the 10-day period doesn't apply, and it's not absurd for it not to apply. Your Honor, I see I'm in my rebuttal time, but I'm happy to continue taking questions. 3C2, Your Honor, is something that'll be the focus of, I'm sure, my friend's comments, and I'll try to address it on rebuttal. Thank you.
Thank you.
May it please the court, I'm Eric Figlio here on behalf of the Department of Commerce, formerly DEO. Here with my co-counsel David Weiss at council table is Paul Schwepp, who represents the intervener, and we're going to attempt to reserve 5 minutes of time for the intervener. Mr. Jazeel is correct that in part our argument relies on 3C2 because, respectfully, I think when the legislature used the word all, I don't think the legislature intended to use the word some. But the reality is it's not really just about 3C2. I mean, the entire statute refers to there are 2 ways to adopt a comprehensive plan in the statute. There's a state coordinated review process in Section E, which doesn't apply. And then there's the expedited state review process, which does apply. And all the references to the statute for the expedited state review process for adoption refer back to subparagraph 3 and 3C1. And there's no other pathway to adopt an amendment through the expedited state review process that doesn't refer back to 3C1. 2A says that if you use the expedited state review process, it's set forth in subsection 3. 3A says the same thing. 3B refers to the initial public hearing. We've been talking about 3C1, which refers to the second public hearing also only. 3C2 is the provision we've all been talking about because however you can construe the section, you have to actively rewrite section 3C2 to come to any conclusion other than, whatever happens at the second public hearing. In no event can adopted amendment be sent later than 10 working days after the second public hearing. And then
So you're saying the local
significantly-
government can't have multiple public hearings? I mean, because, county commissions very often can't come to a decision at a hearing, and they need to talk to their constituents, talk to their staff, and come meet again. You saying they can't do that?
They are absolutely authorized to have at least 2 public hearings, which applies that they can have more than 2 public hearings, however they want to do it. But in any event, you have to construe the statute in pari materia, which refers back to that 3C1 second public hearing. The last provision that I think that the court should focus on is 11, both 11A.
So how do you transmit the amendments within 10 working days after the second public hearing if the amendments aren't adopted till the 4th public hearing?
That's exactly right. That's exactly right. So, and if you look at.
You could have a week of hearings, and each one is a hearing, right? I mean, you could do it.
Or you could view it as the subsequent public hearings as a continuation of the second public hearing.
Sure, absolutely they could, as long as, there are multiple ways you can construe the statute. As Judge Osterhaus suggested earlier, there could be a second public hearing where the local government votes to adopt, and then within 10 business days, somebody changes their mind, they do a quick notice, they have another hearing, and they have further discussion about it. But you have to comply in all events with that 3C2 deadline. 11A contains some very important language both about transmission and about adoption, because it refers back to 3B1 for transmission and 3C1 for adoption. And it talks about how the mechanism for adoption in this statute is by a majority at least of the members of the governing board of the local government present at the hearing. In the case of 3B1, that must be the first public hearing. In the case of 3C1.
Can the parties by agreement extend the deadlines?
I'm sorry, Your
Can
Honor.
the parties by agreement extend the deadline?
They can extend the deadline for the second public hearing. Yes, they can, Your Honor. And, it's an expedited state review process. That is the loophole. You can extend that deadline, and you just have to give notice to the department and all affected parties. But whatever that extended deadline you extend it to, it becomes the new deadline under the statute. So, frankly, between 3C1, 3C2, and 11A, it really decides the issue. You have to actively rewrite multiple provisions in the statute in order to come to any other conclusion than the second public hearing must be the adoption hearing, because 11A says the way you adopt is pursuant to 3C1. There's no other mechanism for adoption under the expedited state review process other than in accordance with subparagraph 3C1, which is the second public hearing. So whatever Mr. Jazeel thinks about statutory history or, the inherent power of local governments, the statute says what the statute says.
You would agree that the current statute makes it a little clearer?
I wouldn't agree that it makes it a little clearer, only because I certainly agree that it makes section 3C1 clearer. That's true. It's just when you read all these provisions together in peri materia, as you must, it still leads to the same conclusion. Their argument requires them to conflict with 3C2 and rewrite it, and to conflict with 11A and explain it. And there's just no other way around it than that.
Does the current statute 11B, and I should have just pulled this, but maybe 11B still envision that there could be, or use this at least 2 hearings?
I'm sure I have it somewhere. I believe it does. I believe it still has that same language. I'm certain there's the opportunity for at least, it's still, I am 99.9% certain it still has that provision in there.
So that just makes it interesting, because if it's here and adopt now, but also at the second hearing, but also
Sure.
contemplates more than 2, then,
Yeah.
yeah.
Yeah, you get the point of the department's argument, is that you don't need to focus on legislative history, you don't need to focus on statutory history to the extent that might have, you don't have to look at any other statutes because all the answers are on this statute. You can either rewrite the entire statute in order to give some kind of extra significance to this at least language, but there's no provision in the statute that explains how you would adopt if you're not adopting at the second public hearing. Because 11A is the provision that describes how you adopt, and it refers back to 3C1. So, if the court has no immediate questions on that, I was going to refer back to the county's argument with respect to count 1. The first point I wanted to make about count 1 is the department has been struggling to understand why, first of all, why count 1 really even matters in this case. I mean, there were 2 independent declaratory judgments that were asked for. Whatever authority the department has or doesn't have to make some kind of pronouncement of its interpretation in this letter, the trial court certainly had authority as a circuit court to determine count 2, which is the substance of this case. So based on how this was alleged, based on the prayer requested in the complaint, we're just not even entirely sure why count 1 is even of any relevance or significance to the court on appeal. Beyond that, with respect to count 1, you have our argument in the brief. We're not sure how you construe the agency's action as agency action. It was a statement of the agency's opinion that the county had not complied with the procedural deadlines that were required by the statute, and by virtue of the fact that they had not complied with the procedural requirements of the statute, they did not have an amendment. That letter has no inherent power. It was not an order. If it was some kind of order, the appropriate venue for determining the validity of it would have been at DOA, but it wasn't. What it did was it put the county and the property owner's rights in doubt.
Where would we be if you hadn't sent the letter and you were just silent? We believe it was withdrawn, so we're just ignoring it.
We would be exactly the same place. And I think that's absolutely right. I don't think there's a deadline.
The amendment wouldn't be approved by the non-response?
No, it's not. It's not approved. And the answer to that is very clearly in the language of 3C4. what that language says, and if you look at the careful citing of that provision in the appellant's briefs, you'll see that the language here is slightly different than the way it's been described. It's 3C4 says, an amendment adopted under this paragraph does not become effective until 31 days after the state land planning agency notifies the local government that the amendment package is complete. So first, an amendment has to be adopted under the paragraph, and then if it's not adopted under the paragraph, there's nothing in the statute that says what it is. It's just,
But you notified them that the package was complete.
that's right. That's right. Because all the references, as you pointed out earlier, all the references in the statute that refer to this, first, it talks about deficiencies, but you read the rest of the paragraph, and the paragraph talks about what are the things you need to do to have a complete package. So a deficiency, as it's construed in 3C2, that's a deficiency in the amendment package. There's something missing that prohibits or forecloses the ability of the state land planning agency to complete an adequate review for determining whether or not they're going to do an in-compliance challenge 30 days later. And there are other provisions. 5B refers to that, and as I just pointed out, 3C4, it describes the requirement of 3C3 as the land planning agency notifies the local government that the plan amendment package is complete. So clearly the legislature, by deficiency, you've got to construe that, paragraph 3, you can't just read that first sentence in isolation, or else what does the remainder of the package mean, the paragraph mean? And the reference to the requirement is, the notification that the plan amendment package is complete in 3C4 and in 5B. Those descriptions don't mean anything if the county's argument is correct. But again, the more important point is, what does it matter? Because an amendment, 3C4 only applies if the amendment is adopted under this paragraph. There's no provision in the statute that says that if a local government wants to adopt a comp plan amendment but chooses not to follow any of the procedural requirements set forth in the statute.
So, counsel, simply stated, is it your position that the second public hearing, as well as the vote, must both take place by the statutory deadline or upon any agreed upon extended deadline?
Yes, Your Honor, that's absolutely our position. Because otherwise, what does 11A mean? 11A says that the way you adopt an amendment is with respect to the expedited state review process where we're operating under is 3C1. 3C1 is the second public hearing. So there's no procedure in the statute for adoption any other way other than the C3C1, which is the second public hearing. But my other point on the procedure is there's nothing anywhere in the statute that says that a local government can choose to ignore the procedure set forth and still have an amendment anyway. There's nothing in here that says it. Certainly there's nothing in 3C4 that says it. And,
Well, how do you respond to the appellant's analysis of 3C2 regarding the 10-day period?
My response is that the word all means all. And my colleagues on the appellant side read all to mean some. All means all. It says that no matter what any of the rest of this means, all comprehensive plan amendments adopted by the governing body, along with the supporting data and analysis, shall be transmitted within 10 working days after the second public hearing of state land planning agency. I don't see any ambiguity in that language.
So all means all, but then in 3, any doesn't mean any deficiencies. It means ministerial completeness deficiencies.
It means deficiencies in that package. That's right. But again, even if you disagree with us on that point, I don't think you should, because if you do, then what does the remainder of that paragraph mean? What does 5B mean, the reference in 5B? What does the reference in 3.4c mean? But even if you disagree with us on that, What does it matter? Because their argument is based on this fallacious premise that any amendment, what if they didn't hold any public hearings at all? What if they didn't allow for any public comment? They just didn't do any of the procedures. They transmitted an amendment to the department, and because the department doesn't catch that they didn't do any of the things they were supposed to do within 5 days, it's an amendment? That's not possible because it conflicts with 3C4, which says in order for that provision to apply, it must first be an amendment adopted under this paragraph. If the court has no more questions, I'm going to reserve the rest of the time for the intervener.
Thank you, Mr. Figlio.
May it please the court, Paul Schwapp, and with me is Francesca DiGilio on behalf of the intervener, Dr. Lewis. Just a few quick points. One is, with respect to the second hearing, C2 of the statute makes it crystal clear that that second hearing must be an adoption hearing. And Judge Roberts, I think you hit the nail on the head. That means a hearing at which a decision to adopt is actually rendered. In this case, the county's position that the May hearing constitutes a second hearing because it was second in time, even though no decision was actually made, would allow them to just continue ad infinitum to consider this amendment without actually making a decision on whether they needed to amend or not. And the reason you know that the second hearing has to be a hearing at which a decision to adopt is actually made is C2 says after the second hearing, you must transmit within 10 days the adopted amendment. And here, as Judge Marsh correctly found, the county blew both deadlines. It did not adopt within the extended deadline, and it did not transmit within 10 days. And Judge Marsh's summary judgment was based on those grounds. The county didn't comply with those statutory deadlines, and those deadlines must mean something. But let me just suggest a couple of additional points. One is that in this case, we're not just dealing with the 180-day deadline because the deadline was extended. It was extended by agreement. And in the record, and Judge Osterhaus, I think you were referring to this, the county, this is at 207, 208 of the record, wrote to the department and requested an extension of the 180-day deadline from April 27, 2022, when it would have expired, through October 27, 2022. And they requested an extension, and this is a quote, to conclude our review and for the board to take final action. In other words,
I understand that that's what staff believes. Staff is with you, but the lawyers aren't with you.
well, Judge, I think what that's telling you is that the county fully appreciated that the deadline in the statute was not a deadline that they could comply with just by holding any hearing, that it was a deadline that they needed to comply with by taking action. And the state acknowledged that, and this is in the record at 1455, the department's letter of April 5 in
But you're
response.
not arguing that the staff letter binds the county?
The argument is in real time, the county appreciated that they had an extension, and the extension was through October 27. And that extension wasn't just to hold any hearing. It was an extension in order to adopt, because that's what the statute required. It required an adoption within 180 days or extended period. And that's what they acknowledged in their letter, and that's what the department granted. In their April 5 response, it's 1455 in the record, the department said the extended adoption date is October 27. So there was no question about it at the time, that that was the date by which the county needed to act, and they failed to meet that deadline. Let me just make one additional point with respect to count 1 in the department's authority. I leave it to the department to argue about its authority, but we respectfully submit that the issue is a bit of a red herring, because in this case, the plaintiffs invoked the trial court's jurisdiction under Chapter 86. This is paragraph 17 of the complaint. They asked the court to declare that the amendment was a final amendment appropriately adopted under the Act. And Judge Marsh, after his authority and his jurisdiction was invoked under Chapter 86, quite properly issued the declaration that the plaintiffs asked for, and he concluded correctly that the amendment was not finally adopted because under the operation of law, because the statute is self-executing, the amendment is deemed withdrawn if it's not adopted within the deadline. And Judge Marsh concluded because it hadn't been adopted within the deadline, it was deemed withdrawn, and so therefore the declaration that the plaintiffs asked for, they got. And so department's authority aside, the trial court, the circuit court, had jurisdiction under 86 to render the declaration that it did, and that should end the issue. Apart from what the January 26th letter from the department means or not means, apart from deficiency, in this case, these plaintiffs came into the circuit court, asked for a declaration, all the proper parties were there, Court had jurisdiction, and it issued its declaration. And I think the final point I would make is it would be hard for me to improve on Judge Marsh's analysis of the statute, and we respectfully request that it be affirmed in all regards. Thank you.
Thank you, Your Honor. Your Honor, I'd like to address the 3C2 point head-on, especially Your Honor's concerns, Judge Osterhaus, about the all-comprehensive plan language. Yes, it says all comprehensive plans shall be transmitted within 10 working days after the second public hearing. But here's the possibility that my friends for the other side foreclose. A comprehensive plan that's not adopted at the second public hearing. Nothing in the statute, anywhere in 3C1 or elsewhere, says that a comprehensive plan amendment shall be adopted at the second public hearing. We have the arguments from my friends from the other side and Judge Marsh saying that a second public hearing is a specialized phrase. Second public hearing is, by definition, according to them and Judge Marsh, the hearing where the adoption happens. No such definition appears in the statute. If we look at the statutory clues, if we look at subsection 3B1, it talks about initial public hearing being the transmittal hearing. That, to me, suggests that there is a sequence. First is first, second is second. It goes away from the specialized definition that the other side is relying on to hem us in and force us to recognize the second public hearing as the adoption hearing. Now, if the second public hearing is not the adoption hearing, how do you read 3C2? The only way to read C32 at that point is if a plan amendment is adopted at the second public hearing, one must transmit it within 10 days. But if a plan amendment is not adopted at the second public hearing, what does one do? The timeline in 3C2 simply doesn't apply. It's triggered if the plan amendment is adopted at the second public hearing. It was not adopted at the second public hearing here. The second public hearing, however, was held within the statutory timelines delineated in 3C1, which does not include the word adopt in it. And with that, Your Honor, I see my time has expired. We would ask the court to reverse. Thank you.
Thank you, Mr. Giselle. And thank all of you. That was really helpful in crystallizing the issues for us. This is our only argument on the docket for today, so we are adjourned.
All rise. You guys flying right now?